Good afternoon, Mr. Chairman. My name is Will Adams. I'm the president of the Texas Trial Lawyers Association, and I'm testifying in support of the bill. Chairman Guerin, thank you for this bill. It's an incredibly important bill to insureds in Texas all over the state. Thank you for not only seeing that it was the right thing to do, but taking the bill and making it your own. I appreciate that. Thank you, Representative Johnson, for your passion. Thank you, Chairman, for your questions. We support this bill wholeheartedly because it is a lawsuit reduction bill. You have heard that it is a bill about a very specific coverage in Texas called uninsured, underinsured motorist. It is a coverage that is not required, but a person seeks out and pays extra money for. Liability coverage is to protect others if I cause a crash. But if I want to be protected from others that caused the crash, I seek out this coverage and pay extra for it. It is particularly important in Texas because of the the amount of minimum policies in Texas, which is $30,000. It doesn't cover much in catastrophic cases. So you buy this coverage to protect yourself in that situation. It's also particularly important in Texas because we heard earlier in this committee, and I've heard elsewhere, that up to 20% of Texas drivers don't have insurance at all. And so we seek out this insurance to protect us in that situation. We are here because the Texas Supreme Court made a decision in Brainerd that an insured needs to go get a judgment before an insurance company needs to do anything. They did this by interpreting the language of the insurance code that the insurer must pay for, and the quote is, amounts that the insured is legally entitled to recover. Not what they would have recovered, like Mr. Thompson said. That's different. Legally entitled to, what does the law allow me as an injured party to recover against a responsible driver? Medical bills, lost wages, money for pain and suffering, physical impairment if I'm put in a wheelchair, disfigurement if I'm burned. These are the damages that we're legally entitled to recover in Texas. That's what that language means. For whatever reason, the court decided that it meant that the UIM insurer is under no contractual duty to pay benefits until the insured obtains a judgment on liability and damages. That is, to be clear, the injured policyholder, before the insurance company must do a thing, must file a lawsuit, must litigate, which often takes 18 months to 2 years, must go to trial, must get a verdict, must reduce that to judgment. And only then does the UIM carrier have to do a thing. Up until that point, they don't have to take your calls, they don't have to read your letters, they don't have to evaluate your claim. They can crumble up the file and put it in the trash and do nothing without consequence. That's absurd, frankly. This opinion has made UIM insurance coverage, has turned it into a fraud on policyholders. And I say that because I guarantee you that not one time that a UIM policy was sold to a consumer were they told, let me tell you what you're going to have to go through to take advantage of this coverage that you're going to pay extra for every month. Because if they were to tell them that, if they were to have to disclose it and maybe get it signed off on, they wouldn't sell one policy except to people who are willing to go through that process. We're one of 2 states that do it this way. 48 states do not require judgments.
Is it unconstitutional in those other states?
That's a good question, and I'll address that briefly. This bill doesn't take away the right of anyone to go to trial. The only way an insurance policy would violate the 7th Amendment is if there was an arbitration clause in it. This bill does not affect anyone's right to choose trial. What it does is it puts some skin in the game for the insurance company to move to do something, to take care of their insured who's paying them premiums, rather than sit back, wait, do nothing, and let the juror be the adjuster. Juries are not adjusters. So HB1739, it fixes this absurdity and brings rationality and fairness back into the process by making clear to everyone that a trial and a judgment are not necessary before the insurance company must act. It says that when liability and damages are reasonably clear, the insurance company must make a good faith attempt to settle promptly and fairly. Before this line of cases, that was always the case. Before legally entitled to recover was interpreted as a judgment, that was always the case. In fact, the words reasonably clear appear in the insurance code and have forever. Insurance companies are supposed to take a certain set of information and make judgments so that their insured's taken care of, rather than waiting 2 years, holding on to the money, and keeping from their insured money that they need. Very oftentimes for things like medical bills.
And it's their own insurance company.
It's their own insurance company. Lost earnings. Folks who have been out of a job for weeks, if not months.
So let's talk about medical bills. What happens? I go to the doctor. I go to the hospital. I'm injured. I rack up a week in the hospital, which is probably hundreds of thousands of dollars in medical bills. What happens to those bills while we're in limbo and in litigation?
So all kind of scenarios there. If the patient has health insurance, it's going to take care of some of that, but the patient's copay often doesn't get paid if the person is without means. Mm-hmm. Oftentimes the doctors wait for months, if not years, to be paid. For the uninsured folks where there's a hospital lien filed that attaches to a settlement, although in this particular situation it wouldn't, so I'll leave that to the side.
And Mr. Chairman, if I can interrupt, also what happens oftentimes is health insurance companies will not pay, saying that they are deferring their secondary to the third-party coverage. So patients get where they have no bills or no coverage. I mean, no medical payer is paying their bills at all, and they start getting collection notices and everything else because there's a dispute.
You mean the providers don't
the
wait
health insurance will say,
patiently for
I'm
the
sorry, but
litigation?
we're not primary. We're going to defer to the third-party liability coverage.
So you have two insurance companies that you're paying premiums to, and neither of them are paying you,
and
paying the doctors.
Right, and the person who's stuck in the middle is poor little claimant who's just hit by a drunk driver and didn't do anything wrong except for pay for their health insurance premiums and pay for their auto premiums, and nobody's paying anything.
So the way these things work is you have to have consequences or teeth if you don't follow the rules. That's why the attorney's fee provision is in there, so that the insurance company knows if I'm not doing what I'm supposed to do, when I'm supposed to do it, there will be consequences. That will make them move. My hope is that makes them move without me. My hope is that makes them move if I'm involved without a lawsuit. Mm-hmm. This is a lawsuit reduction bill, and I will never be convinced otherwise. This will reduce the amount of litigation, unquestionably. I'd like to point out, 92% of Texans purchase coverage from out-of-state carriers. This is the way out-of-state carriers are treating Texans. To fix that, we need to vote favorably on this bill, pass this bill, have this bill signed. It's the only way to change things.
I just want to make clear, you're with Texas Trial Lawyers Association for a lawsuit reduction bill.
That is absolutely right.
Hell of a day. Members, any questions? Thank you so much, Will. Appreciate your time.
Thank you, Mr. Chairman, Committee. Chairman Guerin, thank you.